Hi there, I'm Dr. Suzanne Bechtel, a passionate legal educator dedicated to making legal studies clear, practical, and even a little inspiring. On this channel, you'll find a growing collection of videos designed to help you prepare for the Certified Paralegal exam. It covers key topics, breaking down complex concepts, and offering study tips that actually stick. If you're looking for a deeper dive, check out my Teachable School, where I offer structured courses, interactive tools, and exclusive resources to support your journey towards certification. Watch this video to the end and you'll find a coupon code for a discount. Don't forget to subscribe and explore the playlists. Your success on the NALA CP exam starts here. Now, before we move on to the lecture, there are two important disclaimers. First of all, this is not considered legal advice. Everything shared here is designed to support your learning journey. Also, I am not a lawyer. This course is designed to help you understand the concepts of the exam. Hello again. We are almost to the end of this. Is the second to the last of some lectures that I just decided to plug in as I navigated and built out the other lectures. I just felt like a gap needs to be filled. So this particular one is a gap, and the next one is a gap on procedural stuff. But this one is about the gap that shows up with Chapter 15. So we're going to go through first the key concepts and legal effects. And I have this really fancy slide presentation. Isn't it beautiful? The others would be just as good, but I got started on a different route. Once on the journey, you stay on the same journey instead of changing courses. So here we go. We're going to cover an overview of Chapter 15 Bankruptcy, the scope and key concepts of Chapter 15, legal effects and practical uses of Chapter 15. All right. So, an overview. This slide references information that I found on an overview. So, the purpose and origin of Chapter 15. So, Chapter 15 is not technically a bankruptcy chapter. So, it's not like the others we've covered so far. What it does is it addresses insolvency cases involving assets and creditors in multiple countries. So the court cooperation is the purpose, and in facilitating cooperation between U.S. and foreign courts in managing cross-border bankruptcy cases. And the origin of it was based on the 2005 UNCITRAL model law adopted into U.S. law to guide cross-border insolvency. So it's it started out as a business model. The scope and key concepts. The scope applies when foreign representatives seek U.S. recognition of insolvency proceedings abroad. And the key concepts are to guide understanding of foreign insolvency recognition within the United States jurisdiction. Some definitions to begin with. Foreign proceeding is defined as a judicial or administrative process abroad addressing insolvency or debt adjustment matters. A foreign representative role, that's a person or entity acting on behalf of a debtor in the foreign insolvency proceeding. So let's say the foreign country has something called a trustee in a different language. That would be the kind of how we're looking at it. The U.S. courts can recognize foreign proceedings as main or non-main based on the debtor's interests location. What are the legal effects and practical use of Chapter 15? Well, there is automatic stay protection, barring U.S. creditors from acting against debtors' assets. So now you can see why this stay is something to help protect the foreign assets. Relief options are available. Courts can grant relief, including asset turnover, injunctions, and orders for cooperation. So it's, if you think about that, it's sort of an equity standing that the court also possesses as far as jurisdiction. Third-party releases. Some courts permit non-consensual third-party releases under Chapter 15 to promote comity and enforcement principles. In the real world, though, Chapter 15 has surged because international business and businesses are much more complex. And there's the multinational corporations that are managing cross-border financial and legal challenges effectively. And foreign banks and investments. Foreign banks and cross-border investment structures increasingly rely on Chapter 15. So the role, the international cooperation, and navigating the legal effects, that would summarize what we just looked at. Ancillary issues in bankruptcy. Understanding the role of related bankruptcy proceedings. We're going to look at the nature of ancillary proceedings in Chapter 15, ancillary claims and ancillary relief, strategic role and benefits of ancillary proceedings. And I just thought about this. Let's look up the word. I'll just go to ChatGPT because that's funner. What is the meaning of ancillary? I mean, I know the meaning, but I'd rather tell you, be a little bit smarter. I mean, I can tell you in my own brain what it means. So it's something that is subordinate, supplementary, or supportive to a primary activity or function. So if you think about it in terms of this business context, legal actions that support or relate to a main case. So the main case is a foreign country, problem in foreign country being adjudicated with somebody working with it, the role of a representative. Could look like bankruptcy in another country, could look like some other things, but it's for the purpose of enforcing a foreign judgment in some cases. So definition and nature of ancillary proceedings. I just gave you some of that, didn't I? Sorry, I will admit that I am exhausted. I've been doing this for 7 days straight, relearning and unlearning and learning bankruptcy all over again after years of being out of practice with it. So forgive me. So it's a supportive nature is what they're saying here. It kind of goes along with what I was saying, support or relate a main case. It facilitates that cooperation between U.S. and foreign courts in cross-border insolvency cases, and it complements a primary insolvency case occurring in another country. The key features are, in an ancillary proceeding is a U.S. bankruptcy case, secondary, ancillary, if you will, to a foreign insolvency case initiated by a foreign representative. The purpose of it is to protect U.S. assets, coordinate with foreign courts, and ensure fair treatment of creditors across borders. So an undefined term is ancillary claim. It's not specifically defined in Chapter 15 of the legal text. It causes some confusion. Definition of ancillary relief, however, refers to additional court-ordered financial or property arrangements related to a primary claim. So the types of relief: automatic stay, recognition of foreign main proceedings triggers automatic stay on U.S. assets to protect from creditor actions. Turnover of assets: assets must be turned over to the foreign representative to facilitate cross-border insolvency proceedings. And injunctions are issued to prevent interference or obstruction of the foreign process in the U.S. And foreign creditors gain rights then to participate in U.S. insolvency cases to protect their interests. The strategic role and benefits of ancillary proceedings is probably shed some good light on this. So it's to prevent asset fragmentation Ancillary proceedings prevent piecemeal liquidation of U.S. assets, preserving value and order. It maximizes creditor value, and these proceedings help maximize value for all creditors by coordinating asset management. And jurisdiction cooperation is encouraged. Ancillary proceedings promote comity and cooperation between jurisdictions for effective legal outcomes. So this is a visual breakdown. I can't remember why I included this, but it helped to, I think I meant to delete this. So pardon me, I didn't notice this slide was still in here. I'm going to delete it real quick. So to get a general overview is where we are now. To conclude this, we have this and one more slide after it. Just generally, Chapter 15 in general is cross-border insolvency. That's what it matters. That uncitral model law provides a framework for recognizing foreign insolvency proceedings. And so Chapter 15 was created to do this. Recognition of proceedings is that it guides the recognition of foreign insolvency proceedings as main or non-main based on the debtor's interests in property, etc., in the proceedings. So to conclude this section on ancillary, here's the role, key definitions and claims, and relief types that are available. So that concludes this quick, short, informational mostly lecture. Thank you. I hope you got some good information from this video lecture. Don't forget that I have a Teachable school account. Here is the address for that, mayananda-s-school.teachable.com. The name of my school is Mayananda. And also there's a coupon here for you to save some money. And finally, good luck on the exam. And don't forget to like, share, and subscribe.